where Tamil Nadu Center are clashing over NEP's three-language formula. The center has withheld funds for the Samagra Shiksha scheme in Tamil Nadu due to state's refusal to implement the new education policy of 2020. In a strongly worded letter to the Prime Minister, Tamil Nadu Chief Minister M.K. Stalin last week sought the release of 2000 crore pending for the centrally sponsored scheme meant to support the provisions of RTE Act. At the heart of the clash between the BJP-led centre and DMK-ruled Tamil Nadu is the so-called three-language formula that is a part of NEP. While centre maintains that this policy meant to ensure that youth gets employment across regions, Tamil Nadu has long viewed it as an attempt to impose Hindi on the state. Tamil Nadu has an almost a century-old history of anti-Hindi agitations. Unlike most other states, including southern states such as Kerala and Karnataka, it follows a two-language formula in which its students are taught only Tamil and English. The debate over language form policy in education regarding both the medium of instruction and teaching of languages has existed since independence. The University Education Commission of 1948-49, chaired by Radhakrishnan, who went on to become the second president of India, examined this topic in detail. This was a political hot potato. Even then, the Commission's report notably stated no other problem has caused greater controversy among educationists and evoked more contradictory views from our witnesses. Besides, the question is so wrapped up in the sentiment that it is difficult to consider in a calm and detached manner. The Radhakrishnan Commission favored Hindi as India's federal language to be used for all federal activities, administrative, educational, cultural, where regional languages would serve the provinces. At the same time, the Commission recognized that immediately abandoning English would be impractical. It stated that English would continue as a medium for federal business till such time that all provinces are ready for a change, having spread the federal language adequately. It was this commission that first proposed what would later become the three-language formula in order to enable every region to take its proper share in federal activities and to promote inter-provincial understanding and solidarity. Educated India has to make up its mind to be bilingual or pupils at the higher secondary university stages will have to know these languages. This meant that beyond one's regional language, every person should be acquainted with the federal language and have the ability to read books in English. This proposal was accepted by the National Education Commission of 1964-66 Kothari Commission and was incorporated in National Policy on Education 1968 passed by the Gandhi government. For secondary education, the formula proposed that students learn a modern Indian language, preferably one in of the southern states, southern languages apart from Hindi and English in the Hindi speaking states, and Hindi along with the regional language and English in the non-Hindi speaking states. The National Policy on Education of 1986 passed by Rajiv Gandhi government in, and the latest NEP too retained this formula, although the latter provides for greater flexibility in its implementation. Unlike previous education policies, the NEP 2020 makes no mention of Hindi. The three languages learned by children will be the choices of states, regions, and of course the students themselves, so long as two of the three languages are native to India. This means that in theory a state can teach two Indian languages neither of them being Hindi and, and English. Over several years, the center has maintained that education is in the concurrent list of the constitution and that implementation of three-language formula is the responsibility of states. In 2004, Union Human Resource Minister Arjun Singh and Congress said in Parliament the role of central government in the matter of implementation of three-language formula is recommendatory. Implementation of this formula is sole responsibility of state governments. HRD Minister Smriti Irani of the BJP reiterated this position in 2014, saying it was up to states to finalize their own curriculum. However, now the Ministry of Education has linked the release of Samagra Saksha funds to the implementation of NEP, effectively forcing the hands of the state when it comes to respective education policies. The India-EU partnership, the visit of a delegation of the EU's College of Commissioners led by European Commission President Ursula von der Leyen marks a significant phase in the bilateral relationship between India and Europe. At a time when ties between Europe and United States are facing great pressure, a large delegation of the European Commission College of Commissioners is in New Delhi for a 2-day visit. 22 of the 27 commissioners are part of the delegation led by European Commission President Ursula von der Leyen. This is the first trip out by Europe, the college that took office in December, and the first ever trip to India by the Commission commissioners together. Indian officials said the visit of the College of Commissioners marks a significant phase in bilateral relations as India and EU enter the third decade of their strategic partnership. Meetings of the India EU Trade and Technology Council bilaterals between Indian ministers and EU commissioners and the meetings of the leaders level will diversify engagement and promote trade and investment in range of areas. These include artificial intelligence and semiconductors, as well as green hydrogen, sustainable urbanization, water management, resilient supply chains, defense and space. India established diplomatic relations with the European Economic Community, the first pillar of the future European Union, back in 1962. The joint political statement signed in 1993 and cooperation agreement of 1994 paved the way for strengthening of ties between India and Europe. The multi-tier institutional architecture of cooperation has been presided over by the India-EU summits, 15 of which have been held so far. The first summit was held in Lisbon in June 2000, and the bilateral relationship was upgraded to a strategic partnership at the fifth summit in The Hague in 2004. Prime Minister Narendra Modi and the European Commission President Ursula von der Leyen have met at least 7 times in the past. The President had paid an official visit to India in April 2022, during which she participated in the Raisina Dialogue as chief guest and delivered the inaugural address. Prime Minister Modi and President von der Leyen met briefly on the sidelines of G20 Rio Summit in November 24. In January this year, PM spoke by the telephone with the President of the European Council, Antonio Costa. The India-EU Strategic Partnership, a roadmap to 25, was adopted at the last India-EU Summit in July 2020. At the leaders' meeting in May 21, the two sides announced the resumption of negotiations for a comprehensive free trade and investment agreement and an agreement on geopolitical indications. They also launched an ambitious connectivity partnership. During their meeting in 2022, Modi and von der Leyen announced the establishment of India-EU Trade and Technology Council as a strategic coordination mechanism to tackle challenges at the nexus of trade, trusted technology, and security. The Trade and Technology Council, a new frontier similar to Initiative of Critical and Emerging Technologies with the US, or the Technology Security Initiative with the United Kingdom, represents three significant pillars of India-EU cooperation: digital and strategic technologies, clean and green technologies and trade investments, and resilient supply chains. The first ministerial meeting of the Trade and Technology Council was held in May 2023. The second meeting will be held in New Delhi on Friday. In the various meetings between the two sides, the issues of global cooperation, including the ongoing war in Ukraine, in which US under President Donald Trump has done a remarkable switch, leaving the Europeans in lurch, is certain to be discussed. India and EU have been negotiating a free trade agreement on the last decade and a half. Economic argument for an agreement is strong. The EU is India's largest trading partner in goods, and bilateral trade has increased 90% Over an past decade, bilateral trade in goods was $135 billion in FY 23-24, with Indian exports to the EU accounting for $76 billion and imports for $59 billion. Bilateral trade in services in 23 stood at $53 billion, comprising India's exports of $30 billion and imports of $23 billion. Bilateral trade in goods was $135 billion in 23-24, with Indian exports 76 and imports 59. Services 53. So 135 plus 53 is 187. 188. Total trade is $188 billion. Cumulative foreign direct investment flows from the EU during the period April 2020 April 2000 to 2004 was $117 billion, which represented 16.6% of the total FDI equity inflow. Indian FDI outflows to the EU are valued at $40 billion. The technology partnership between India and the EU are assumed greater significance and urgency in view of China's advancements in this field. Bilateral science and technology cooperation is carried out within the framework of Science and Technology Cooperation Agreement of 2007, and India-EU intent of cooperation in high-performance computing was signed in November 22, and in November 23, the two sides signed a memorandum of understanding on semiconductor R&D cooperation. The following month, the EU participated in the Global Partnership on AI Summit in New Delhi. Under the India-EU Green Hydrogen Cooperation Initiative, India was exclusive partner country at the India was the exclusive partner country at the European Hydrogen Week in Brussels in November 24. The EU was a major partner in the International Conference on Green Hydrogen in Delhi that September. The European Investment Bank has committed to supporting Indian hydrogen projects with funding of 1 billion euros. Indian and European companies are collaborating in the renewable and hydrogen sectors with an aim of developing green hydrogen ecosystem in India by 2030. Strong and growing people ties is one of the foundations of India-EU relationship. The growing Indian diaspora in the EU contains large number of students, researchers, and skilled professionals. Indian professionals received largest share, more than 20%, EU blue cards issued in 2023-24. Over the last 20 years, more than 6,000 Erasmus scholarships have been awarded to Indian students, making them among the top recipients of the scholarships. More than 2,700 Indian researchers have been funded. Marie Sklodowska-Curie Actions, part of EU's research and innovation program Horizon Europe since 2014, the most in the world. India and EU are strengthening their defense cooperation, especially in maritime security and Indo-Pacific region, under the ESIWA Plus Security Program. ESIWA Security Plus ESIWA Plus Security Program. This is crucial in the context of China's growing maritime heft. Under the India-EU Green Hydrogen Cooperation under the India-EU Green Hydrogen Cooperation Mission under the India-EU Green Hydrogen Cooperation Mission initiative, India was exclusive partner country at the European Hydrogen Week in Brussels in November 24. The EU was a major partner in the International Conference on Green Hydrogen in Delhi in that September. The European Investment Bank has committed to supporting Indian hydrogen projects worth funding of 1 billion euros. strong people to people ties is one of the foundations of India EU relationship. The growing Indian diaspora in the EU contains large number of students, researchers and skilled professionals. Indian professionals receive the largest share, more than 20% of EU blue cards issued in 23-24. Over the last 20 years, more than 6,000 Erasmus scholarships have been awarded to Indian students, making them among the top recipients of the scholarships. More than 2,700 Indian researchers have been funded by Marie Sklodowska Curie Actions, part of EU's Research and Innovation Program. India and EU are strengthening their defense cooperation. Bilateral trade in goods was $135 billion, with India's exports to EU 76 and 59. Bilateral trade in goods was $135 billion, with India's exports to EU $76 billion. Trade in bilateral trade in services was $53 billion, with 30 and 23. 135, 76 and 59, and $53 billion. Cumulative foreign direct investment flows from the EU during the period April 2000 to September 2024 was $117 billion, which represented 16.6% of the total FDI equity inflow. India established diplomatic relations with the European Economic Community, the first pillar of future European Union, back in 1962. Joint political statement signed in 93 and cooperation agreement in 94 paved the way for strengthening ties between India and Europe. India and EU are strengthening their defense cooperation, especially in maritime security and Indo-Pacific region under ESIWA Plus program. This is crucial in context of China's growing maritime prowess and aggressive policies. The first joint naval exercises were held in October 23 in the Gulf of Guinea, and the two sides have stepped up cooperation on global security, natural disasters, piracy, and counter-terrorism. The ISRO's PSLV successfully launched the EU's Proba 3 mission. In December 24, ISRO and ESA have cooperated on the Chandrayaan 3 and Aditya L1 missions, signed on MOU for cooperation on Gaganyaan, India's human spaceflight mission. In Supreme Court staying Lokpal order on High Court judge, the questions of complaints procedure. The Supreme Court last week stayed a Lokpal order that took cognizance of the corruption complaint against an unnamed High Court judge. In its January 27 order, the Lokpal bench, led by former Supreme Court Judge A.M. Khanwalkar, held that it had power to hear corruption complaints against former judges under the Lokpal and Lokayuktas Act 2013. However, in 20 January 27 order, the Lokpal bench, headed by former Supreme Court Judge A.M. Khanwalkar, held that it had power to hear complaints against former judges under the Lokpal and Lokayukta Act 2013. However, the Supreme Court took suo motu cognizance of the case, and bench of Justices Gawai Suryakant and Oka called in something very disturbing while staying the order. The next hearing has been posted for March 18. Well, the Supreme Court has previously acknowledged criticism of judges. Its response has always been balanced with its efforts to protect the independence of judges and the judiciary. It has sought to establish safeguards against possible cases of executive outreach. Lokpal is an independent statutory body that is under the aegis of executive. Admitting its January 27 order could have opened new avenue for complaints against judges without abiding by the process earlier laid down for such cases. Section 77 of the Indian Penal Code 1860 effectively states that a judge cannot be charged with an offence if the allegation related to the exercise of her official duties. The provision has been reproduced as Section 15 of the Bharatiya Nyaya Samhita 2023. The Supreme Court added an extra layer of protection in K. Veeraswamy versus Union of India. Justice Veeraswamy, a former Chief Justice of the Madras High Court, was being investigated by CBI in a disproportionate assets case and had moved to quash the case. Supreme Court held that he was a public servant and could be investigated for offences under the Prevention of Corruption Act 1947. However, the courts also held that President must sanction any criminal case against a judge after consulting the Chief Justice of India to protect a judge from frivolous prosecution and unnecessary harassment. The President is bound by the advice given by the CGI. Notably, the procedure for filing a case against a sitting judge is different from the procedure for impeaching a judge, where approval is required by the Parliament. Two complaints were filed against High Court judge alleging that he had influenced an additional district judge and another High Court judge who were hearing suits filed by a complainant against a private company. According to the complainant, company was a client of the judge when he was still an advocate. The Lokpal order only deals with whether it had the power to hear a case against a High Court judge and not the merits of the complaint. Justice Veeraswamy, a former Chief Justice of Madras High Court, was being investigated by CBI in a disproportionate assets case and had moved to quash the case. Supreme Court held that he was a public servant and could be investigated for offences under PCA 1988. However, the court also held that President may sanction any criminal case against a judge after consulting the Chief Justice to protect a judge from frivolous prosecution and unnecessary harassment. The President is bound by the advice given by the CGI. Notably, the procedure for filing a case against the sitting judge is different from the procedure for impeaching a judge, where approval is required from Parliament. Two complaints were filed against the High Court judge alleging that he had influenced additional district judge and another High Court judge who were hearing suits filed by a complainant against a private company. According to the complainant, company was a client of a judge when he was still an advocate. The Lokpal order only deals with whether it had power to hear case against an High Court judge and not the merits of the complaint. Lokpal Act states it shall apply to public servants in and outside India. The term public servant is defined under Section 14 of the Act. While it does not explicitly include judges, subsection F states that it includes any person who has been chairperson or member or officer or employee in autonomous body established by a act of parliament or wholly or partly financed by the central government or controlled by it. In a separate case in January, Lokpal applied this definition and ruled that it cannot hear cases against Supreme Court judges. It held that Supreme Court was established under Article 124 of the Constitution and not an act of parliament. However, in the present case, Lokpal found that High Court judges do not share the same status. Several High Courts were established and restructured under the High Courts Act 1961 and Government of India Act 1935. Lokpal noted that these would be considered as an act of parliament as the General Classes Act 1997 specifically states that an act of parliament will include an act passed before the commencement of the constitution. The Lokpal stated it would be too naive to argue that a judge of a high court will not come under the ambit of the expression any person, but given the K. Veeraswamy ruling and out of abundance of caution, it noted that engaging in further proceedings before the Lokpal inevitably involves a probe into the allegations involved against the judge of a high court. Thus, before conducting an inquiry, Lokpal ruled it would be appropriate to forward the complaint to the CGI for guidance on how to proceed. Lokayukta Act states it shall apply to public servants in and outside India. The term public servant is defined in Section 14 of the Act. While it does not explicitly include judges, subsection F states It includes any person who is or has been a chairperson or member or officer or employee in any autonomous body established by an act of parliament or wholly or partly financed by the central government controlled by it. Philanthropy in numbers taking stock. 95% social sector funding comes from public funding. India's total social sector spend on education, healthcare, etc. is expected to be roughly 25 lakh crore. Of this, 23 lakh crore will be from the government. 40% private philanthropy comes from UHNI, HNI families. 2% families responsible for 50 to 55% CSR by family businesses. Growth in private spending in social sector will be on the back of family philanthropy from ultra high net worth individuals, HNIs and affluent individuals. Strategic services and structured support could unlock 50 to 50,000 crore in additional family philanthropy. So that's all. See you in the next one.